Wonderful. We're going to get started with our next panel, and that is moderated by the wonderful Julia.
Hi everyone, can you hear me all right? So my name is Julia McLeod. My pronouns are she, her. As a visual description, I am a white woman in my late 20s with very short, dark brown curly hair and bangs, and I'm wearing a great sweater. And I'm really excited to moderate this panel today with all these awesome experts. Also, I am the Reproductive Justice Legal Fellow at the Disability Rights Education and Defense Fund, or RRLI. I'm kind of going by legal fellow now because I'm doing like broader work, but a lot of my focus has been collaborating with Amanda on improving access to abortion and reproductive healthcare for people with disabilities. And I'm excited to be here with Professor Bruce Kolker, with Professor Jasmine Harris, who is up here on the screen behind me, with Professor Stephanie Hoffer on the far end, and then with Dr. Susan Hatters-Friedman, and I will let them all introduce themselves, and we'll start with Professor Kolker.
Well, thank you, thank you, organizing. This is just one of the best conferences I've been to in my life, and I'm turning 69 soon, so that's saying a lot. So thank you. This is just like really amazing. My name is Bruce Kolker. As I just said, I'm a 69-year-old white woman with a bunch of gray hair, as one might expect. And I'm wearing a purple sweater, which is my favorite color. That's probably all you need to know about me. But in terms of my bio, I started my career as a civil rights attorney in the trial division of the Civil Rights Division at the United States Department of Justice. And the president at that time was Ronald Reagan. But that seems to be in comparison. When he was reelected, I decided I couldn't imagine there ever being a president who I could admire, so I left and became a legal academic. It was not what I expected to do with my career, but I did, and I have now finished, I think, my 40th year in the academy. So I am definitely.
I'm sorry. Just you move the mic closer.
Sorry, I'm definitely a appointed head academic whose voice has gotten softer as I've gotten better. So our panel, I think, was assigned the topic of thinking about reproductive justice issues from the perspective of people with what we might call less transparent disabilities. And so that's what I'm going to try to center my comments on today. And in listening to this morning's panel and thinking about my remarks, I want to embrace the importance of intersectionality as we think about this topic, because I think sometimes when we talk about people with less transparent disabilities in our mind, we often think of white people. When we think of people with learning disabilities, people with ADHD, we think of people with anxiety disorders. And I know, having been on the best practices panel for the Law School Admissions Council lawsuit, that many of those people are white. Because white people are more likely to have access to the resources that provide them with that diagnosis, and also our medical system is so biased that it thinks that those are white conditions, right? And when Black and brown people have those characteristics, they get other labels like defiant disorder or whatever, or you don't know these things, these words that are not within my expertise. But anyway. So when I think about these issues that I'm going to try to discuss, of course, I don't want to be just talking about white people. I'm not that I don't think that white people are important, but I think that they shouldn't be the only people we talk about in this space. And so as I was listening to this morning's panel and I was trying to like center my mind about who I have in mind, I was thinking of one of the more interesting students I've had in my 40 years of teaching. He was a Latino student whose parents were immigrants in the United States, who was in a car accident when he was 2 years old and used a wheelchair to ambulate. And I had him for legal writing in his first semester of law school. And after I saw his writing and I discussed with him some challenges I had with his writing, I said to him, has anyone suggested that you might have a learning disability? And he said, no. I said, well, and I sort of talked to him some more, and his first language was Spanish. He wanted to speak English when he was in the hospital when he was 2. And so he said, you know, my challenges with reading, people always just thought that was because my first language was Spanish and I was a wheelchair, like that would affect how well I read, right? And I said, okay, well, I don't want to like suggest anything, but we do have an office of disability services. I think we can offer you some financial assistance to get tested, you know. So you go get tested and yeah, he was like in the 99th percentile for a learning disability. And here he was, I mean, he was 23 years old. He had gone through high school and college, and it wasn't until by chance he had me, the disability person, you know, teaching legal writing, that this even came up with a thought. And, you know, we stayed close, and he was an incredible student and brilliant and wonderful and has had a great career that I have followed. But, you know, I think about him, I think about people with less transparent disabilities, because it is also an intersectional problem, right? He presents as somebody who's a wheelchair, like that's obvious. He looked Latino, he sounded Latino, he had, you know, a bit of the accent that's typical people whose first language is Spanish. And that just didn't occur to someone to think about other aspects of his personality of who he is. So I guess I would like to start with us all remembering that. I mean, I probably don't have to tell this room that, but it's good for me to remind myself of that when I look at my students and I see some transparent elements of them, which might be their race, it might be some visible disabilities like using a wheelchair. That doesn't mean that they don't also have to have these other characteristics that sometimes we think of white people as exclusively having. So that's my sort of, I guess, my big point. My two more minor points, I guess, in terms of what I have to say today. It's so hard to add to today's conversation. Like, you've said so much that I almost thought I'd say, I yield my time. It's hard to think of new things to say, but I'm just going to make 2 points and take them for what they're worth. And I'm often people challenging these observations as maybe not even being useful, because I do mostly sit with that academic pointed hat on. So the 2 issues I want to talk about is, first is the issue of what I call over medicalization. To just think about whether sometimes we over medicalize this space, and just to be careful we don't do that. And the second is, and I don't think I've heard people talk about this, but like, I know abortion medication is super important. Mifepristone, if I can pronounce it correctly, is super important. But I sometimes worry that maybe our over reliance on abortion medication might disparately impact some people in our community who have less visible, less transparent disabilities. And I'm thinking about anxiety disorders, but I'm sure that's not the only category for which that might be true. So I'm just going to raise these 2 points as a thought experiment for those of you who are actually out there in the world and are doing the real work, which I am not doing in the way that you are. And I'm in awe of what you do. So let me just first talk about over medicalization. As Jessie knows, I wrote an article about it, and I know Jessie's book on that, and I appreciated it in her own work. So over-medicalization is a tendency to think of issues from a perspective that emphasizes the physical nature of disability, often overlooking what we would all call the social construction of disability. I think this is a really important political moment to mention that, because as I'm sure you know, the Department of Education is planning to transfer special education to HHS. And that is like the opposite of the way we think about disability in education, right? We don't think of disability primarily a health issue. I mean, it can have health aspects for sure, right? But we know that in the educational context, so much of being disabled is a social construction of disability, the way education takes place. So I think we can't scream loudly enough in the current political time that disability is not primarily a health issue. And so I'm sort of reminding us of that in this space. And so, you know, what have I done in my own work in thinking about people with less transparent disabilities in ways that don't require over medicalization? So I've worked a lot on universal design in the educational setting. We were talking about that earlier. It's a really important principle. And by using universal design principles, I can try to reach the whole class and not require my students to get that medical certificate that says that they officially have, right, this ADHD or anxiety disorder or learning disability that would allow them to get some of the teaching tools that I use. And so, if we move towards a more universal design space, then that helps alleviate some of the pressures on the healthcare system for some people with various less transparent disabilities. And so, today, as often happens in spaces where we talk about reproductive justice, you know, when we talk about stories of people who are being adversely affected in the current political climate, there's so many stories, right? It's like every person potentially pregnant is a story because of the way your anxiety has to be heightened. At this time, if you're someone who can possibly become pregnant. But I think it's important that we make sure that we don't only tell stories of people who have toxic pregnancies and are gonna die if they're continuing the pregnancy. There are just so many people who, and I don't mean to say just have, but do have, anxiety disorders and ADHD in a way that makes a pregnancy always difficult, and now even more difficult as it has to worry of what will happen if they're having challenges during the pregnancy. And I can say that during my various pregnancies, I had 3 miscarriages, and I hear these stories now of people not getting miscarriage care. We haven't talked about that today, but that's awful. And I think about how would I have felt as a pregnant person if I had to worry that if I had yet one more miscarriage, that I would be able to get the healthcare treatment I needed so that I could become pregnant again in the future, by choice. And so, so I think there's just so much in, like, how can you not be anxious in this political climate, right? And then how could you not be anxious as someone who's potentially pregnant? And so I think it's important for us to just remember that that is like a static norm right now. And that's a story we need to be telling instead of only telling the story of people who have healthcare crises that could land them in the hospital or whatever. And as Dr. David knows, as he's here with me today, I have a niece who recently gave birth and someone has a lot of anxiety, and hearing her talk about like how incredibly anxious she was during her entire pregnancy and how anxious she is as a new parent, and she's a privileged white woman. I just think, what would that have been like from an intersectional perspective if she hadn't had the financial support of family and friends during the pregnancy and afterwards? And so this sort of anxiety stuff is just hugely important. And I just hope that in this space we make sure that we think about it. So that was my first issue. I think it's important to just push back when we hear what I call over-medicalization. Then the second thing is abortion medication. Now, I am like a huge fan of abortion medication. This is fantastic. It's a game changer for so many people, and it's allowing obviously people who live in states with abortion bans to find a way to have an abortion. So like, this is great. It's a game changer. I hope the Trump administration isn't able to eliminate it. So nothing I say is going to suggest that that's not a fantastic development. But then, I think about, from what I know about mifepristone and the way it's supposed to be used, people are told that you only should use it for 10 or 12 weeks of pregnancy. And as we all know, many people don't realize that they're pregnant until they're at least 6 or 8 weeks pregnant. That really doesn't give them very much time to access abortion medication, find a way to take it safely. And it doesn't give them much time to figure out what they want to do with pregnancy. I don't believe in waiting period rules. I have filed lawsuits against states with waiting period rules because I lost those lawsuits, but at least I tried. So I'm not in favor of waiting period rules, and I think it's incredibly paternalistic to tell women that they absolutely have to have like this many hours of contemplation. That's ridiculous. On the other hand, some people take more time to process and take more time to think through decisions, and that's good. We value that in them. That's fine. And so, so it's important for there to be options in addition to mifepristone, not as the only way to have an abortion. When I see these statistics that over half of abortions now, half of abortions take place through the use of abortion medication, I'm like, well, that's cool, because that probably means a lot of women and other people in a state with abortion pain are still having abortions and they're getting these drugs. Like, that's good. But I'm concerned that we're going to move to a space pretty quickly where that's the only vehicle available within the time limits that exist for its safe use. And we're hearing stories about people who take it later in the pregnancies, right, and they have some adverse health outcomes because it's not indicated to be taking it at 18, 20 weeks of pregnancy. So, so I just, again, it just, for those of you in the field, I know you know much more about what's going on than I do, but I just, I just want to say, let's make sure that we're thinking about the full set of constellations of characteristics that people have when they're pregnant. So those are just like preliminary thoughts, and I really came today to listen, because I don't really usually get to hear from people who actually are working in the community, and I just really thank you for being here and helping to educate this old white woman on what's going on in today's climate. So thank you, appreciate it.
Well, thank you so much, Professor, and we'll move now to Professor Harris.
Hi, good afternoon, everyone. My name is Jasmine Harris, and I'm a professor of law at the University of Pennsylvania Carey Law School. And I just want to echo Professor Kolker's thanks to organizers, to the moderator. Can everyone hear me okay?
We're turning the volume up a little. It's a little bit quiet.
Okay.
I think we're gonna try to put a microphone next to the speaker.
Okay. I can also turn it up to New York mode, which is where I grew up, and I will be shaking the room with my New York voice. Is this better already?
How is that?
Excellent.
A little louder or?
Is the volume up on her computer too?
It sure is.
Okay, good. There you go.
It sure is. Should it be up further? I feel like it's pretty high, but if you need me to turn it up higher, I can, of course.
That's great, Professor. Yeah.
Okay, excellent. So let me just quickly say thank you again to the organizers, to our moderator, Jillian, to my co-panelists. Actually, I skipped over my own introduction in terms of my visual description. I will stop for a moment to do that. I am a middle-aged Latina woman, and I'm wearing red-rimmed glasses, and I have brown hair. And I'm just delighted to be here with all of you today to continue the conversation. I'm sorry I couldn't be there with you in person. I do want to also quickly shout out the organizers and the practitioners in the room. Thank you so much for all that you do. As Professor Kolker said, we value everything that you do, and you're really the ones who we hope to learn from. And so I bring you these comments in a very humble way and hope that we can begin to have a discussion together. So I want to pick up on the theme of choice and to consider the ways in which it interacts with legal constructions of consent to restrict individual reproductive choices. I'm going to focus my remarks today on the choices of people with intellectual and developmental disabilities for whom the challenges of consent are perhaps clearest. Recognizing that part of the challenge here was to talk about people with less visible disabilities, but I will say I'm still within that zone because I am talking about the continuum of people with intellectual and developmental disabilities, which is quite broad, and which includes things such as what Professor Kolker was saying in terms of ADHD and other disabilities that are less apparent. It's important to recognize that the conversation, though, is much broader. So the goal of the gathering, as I understand it, is to say and show why a conversation about reproductive justice, or any conversation about reproductive justice, must include disability. So a few opening notes. As I just mentioned, people with IDD are not a monolithic group. Further, the discussion along the single axis of disability shouldn't mask the experience of multiply marginalized individuals. It really calls for us during this discussion to examine other axes of historical subordination, such as gender, race, religion, sexuality. One other opening comment to illustrate one goal of my presentation and my opening remarks. The organizers made a deliberate choice to frame the discussions as one of reproductive justice and not simply reproductive rights, similar to the decision to frame it as not disability rights, but disability justice. Possession of a right is important, but the ability to exercise that right gives it meaning. In the context of consent, for example, consider a woman who is a wheelchair user going to see a gynecologist to decide whether or not, or rather how to respond to a chronic and debilitating endometriosis diagnosis and the possibility of a hysterectomy that's on the table. But the transportation to the office is inaccessible. And upon arrival, the medical equipment and even the examination table are all inaccessible. So why do I say this? Reproductive choices occur in a broader context where disability rights must be enforced to make reproductive rights meaningful. So why talk about consent? Laws for consent touch almost every substantive area, from criminal laws, such as sexual assault, to civil contract laws around purchasing a home. At its core, what does consent mean? There are lots of differing views, but it's voluntary informed agreement between an individual and another person, people, an organizational entity, or even the state. The absence for consent in our world of law as lawyers is grounds for criminal or civil liability and the introduction of remedies. But there's a real disconnect between legal constructions of consent as individual, informed, and the methods of agreement that do not reflect the lived experiences of decision-making for many people, not just those with IDD. Hence, another lesson that we as scholars, practitioners, advocates, and people with disabilities can reflect out more broadly into reproductive justice spaces. Let's take that opening example that I gave, but change it to a woman with an intellectual disability. Let's say Down syndrome, who's going to a new provider, a GYN, to discuss endometrial pain and treatment options, including this hysterectomy. The woman K assumes she's 19 years old. She has speech, but she uses a communication app on her phone because it facilitates communication. Just so you know, the lawyers in the room, not an actual case, but is an illustrative amalgamation of so many others that we hear. The medical provider is a frontline assessor here with respect to consent, and the law presumes capacity to consent for those who have reached the age of majority unless otherwise specified. Medical training, however, may limit the provider's experience and prior knowledge of how to effectively provide care to individuals with IDD. This provider may assume that K, because of what in my prior work I've called the aesthetics of disability, those markers that represent social constructions of incapacity, such as non-normative speech, which here K uses a communication app, facial features, such as those that mark particular individuals as individuals who have Down syndrome. And the provider may assume that because of these features, that K lacks the capacity to make this healthcare decision, or that she fails certain perceptions of what the provider believes capacity to consent looks like and requires. The medical bias here is real. A study by Dr. Lisa Iazzoni that many of you in the room are familiar with, she and her colleagues surveyed 714 practicing US physicians and found that 82.4% believe people with significant disabilities have a worse quality of life than non-disabled people. And only 40%, 40.7% to be exact, of physicians were very confident about their ability to provide the same quality of care to patients with a disability. And just 56.5% strongly agreed that they actually welcome patients with disabilities into their practices. These biases are real and deeply rooted in our history of eugenics and presumptions about fitness to reproduce, parent, and all that we've known over time. And we know that it historically, as I began with, has fallen heavily on multiply marginalized people, from Carrie Buck and Buck versus Bell, to the Relf sisters, to the Mexican-American women and immigrants in the Madrigal versus Gilligan case out of Los Angeles. So what does the capacity consent actually require? And would K have the capacity to consent to a hysterectomy in my example? This framing of the question is the way law would care about it, as if it was reviewing this in the context of a tort case. But if we're concerned with this question and this framing, we've missed what's happening in the interaction between the provider and K. K has not presented the provider with any reason to presume incapacity to consent. Like the provider would do with any other patient, the evaluation of consent comes through discussion and exploration of the decision. I want to raise a few red flags before turning it over to the next participant. Flags that might commonly arise in this process that are barriers to the exercise of reproductive rights and complicate what we understand as consent. The law understands this interaction as one that raises the question. If you're going to ask law students, they would probably respond here, this raises the question of incapacity to consent. And as I began with, the law has a very narrow view of what consent means and what it looks like in different contexts. So I want to say that historically, people with IDD have been presumed incapable to make decisions and have required in the context of healthcare decisional proxies, most often thought of as legal guardians. But the operation of guardianship itself has been an on-off switch, where courts have assumed blanket incapacity and ordered plenary guardianships that remove all legal capacity from the individual and place it in the hands of a guardian. Over time, through advocacy from disabled people, including self-advocates with IDD, states have reformed their guardianship laws to favor limited guardianship over plenary ones. The proper inquiry ought to be capacity for what? That is, when someone says, is this person incapable? You respond with capacity for what? And one way of thinking about it is through the lens of disability. Can the person consent with or without a reasonable accommodation? So the last point I want to raise is with respect to informed. So we talked about the method of consent being non-normative communication and that we need a broader understanding. Voluntary presents a whole set of issues we can talk about during the Q&A, but informed. While Kay can receive the information from the provider, Kay may or may not need the assistance to process the information, and not just Kay alone. This is thinking about universal design. Our healthcare system is structured around a very fast decision-making process. But the time constraints may in fact lead the provider to believe that Kay cannot make the required decision in the amount of time provided and therefore lacks capacity to have that decision be her own. Or if Kay brings a friend with her for support, the provider may interpret this individual's presence as another indication of incapacity to individually and independently consent, which, by the way, is our legal understanding of how an individual can express and should consent individually, independently, voluntarily by one's own self. Whereas the individual's presence may show, as many in this room understand, that in and of itself is a supporter that is going to help with the decision-making process. The substance of the decision to have a hysterectomy, provider biases may shape the nature of the conversation and how the provider presents the benefits and risks. For example, a provider may undervalue Kay's desire to be a parent in the future, assuming that this may not be possible because of her disability, or alternatively, make assumptions about Kay's sexual relationships and activity. Similarly, based on perceptions of IDD as asexual, childlike, or at the other end, hypersexual. This may lead to framing medical and the way medical ethics decisions, and some of them have said hysterectomies allow for greater sexual agency for women with disabilities, used as a method of birth control. Or at the other end, given the sobering rates of sexual assault of people with IDD, 7 times the rate of non-disabled survivors, conversations about sex may seek risk aversion and overprotection that deny an individual's sexual reproductive agency. So just to return to that proper question, the law will ask its question post hoc to determine liability and remedies. And when we think about reproductive justice, we think about legal cases. That's perhaps because that's the lens that lawyers have. But the bread and butter of reproductive justice takes place outside of courtrooms, upstream, through everyday interactions like the one that I presented here. The laws regulating the interaction between Kay and the provider matter, both to the provider and Kay, but the operation of problematic norms and education, with the absence of education about disability, give content to those rights. And that's where we also need to invest our time. So thank you very much.
Thank you so much, Professor. And now we will move on to Professor Stephanie Hoffer. Lots of professors here today.
Thank you so much. I'm Stephanie Hoffer. I am a middle-aged woman with red hair and glasses. They're blue now. And I'm wearing a blue suit. I'm delighted to be here. I am the Lawrence A. Jagan III Chair in Tax Law at Indiana University, and it is a delight to be with you today. And I want to begin by thanking Maggie for inviting me and thanking all of the wonderful people who brought us together today. This really is an honor, and I'll confess to a little bit of imposter syndrome taking the podium in front of all of you. I am neither a true disability scholar, nor am I a reproductive rights scholar. I study tax. Tax. I am, however, a mom. In 2010, a year before non-invasive prenatal testing became available, I was pregnant with my first son. His name is George, and he's 14 now. There were some early indications while I was pregnant that George may have Down syndrome. I was in the high-risk obstetrics practice at Ohio State's hospital, because they labeled me, this is a thing that they actually write on your file. I was labeled as an old mother. They left off the third word, I think. Anyway, I was in the high-risk practice, and when you're in that practice, you see sometimes a different obstetrician in each visit, and you have many visits. I was encouraged by one obstetrician after another to confirm a diagnosis of Down syndrome through invasive testing so that I could abort my son before it was too late. Like they were trained to do, the doctors focused on what they perceived as risks, and they told me that my baby might be born with a hole in his heart, that he might have no openings in his intestines, that he might never speak, perhaps he wouldn't walk. And one white-haired old venerable went so far as to say that my son would not have a good life, because he would never be, I'm quoting, these are not ironic air quotes, he would not be normal, and it would be better for both my son and I if I, quote, took advantage of my choices. We've talked a little bit about the conflict or tension within the disability community regarding reproductive rights. I wanted and loved my unborn son, and I told each obstetrician along the way that that was the case. And so when I had appointments like this, I went home, or I went back to my office, and I shut the door and I cried. The medical establishment had already passed judgment on George, and it passed judgment on me every time prior to 20 weeks. I refused to get a test that would, in the opinion of my care team, prove that my son, thank you, should not be given life. You know, I packed some because I was afraid of that, but I left them in the back of the room, so God bless. My story is not an exception in Ohio. It's not an exception in many states. And at the time, it was the norm. The birth rate for babies with Down syndrome in Ohio, as across the nation, was low, with some estimates being that about 60% of mothers or pregnant people choose to abort those pregnancies. No doctor at the time was ever required to tell any expectant parent that their child with Down syndrome would likely go to the neighborhood school, have friends, laugh, fall in love. My son last year in school dissected the brain of a sheep and talked about it at the dinner table. Even though those outcomes, the dissection of the sheep brain or falling in love, are far more likely than the terrifying medical consequences that were described to me by the doctors who cared for me during my pregnancy. George, for what it's worth, loves the music of John Williams. He's excellent at the baritone horn, and he can take a 3-point shot about 30% of the time, and that's pretty good odds from my perspective. And so what the doctors told me may have been true for some parents, but definitely not for all, not for most. Shortly after George's birth, the government approved non-invasive prenatal testing. So now by 10 weeks, you can know whether the child that you're carrying has the chromosomal difference that produces Down syndrome, and there are a few others that are included in the test. And this brought the issue of Down syndrome abortion to the forefront in the national media. So it's here that we reach a fork in the road. Within the community of families of which mine is a part, the consensus at the time was that a decent chunk of obstetricians were just absolute dinosaurs who were undereducated about Down syndrome, and they just lacked up-to-date information and the time to get it. Outside of our community, people saw the low birth rate for babies with Down syndrome as eugenic. Some people even referred to it at the time, talking about Iceland, as genocide. Before talking a bit more about the conservative co-option of the term eugenics, let me note a point of perceived consensus. Policy folks both inside and outside of the Down syndrome community agreed that the birth rate of babies with Down syndrome was abnormally depressed, and most agreed that the reason was that families had a misperception of the quality of life of individuals with Down syndrome, and that some people didn't understand the value of a life with Down syndrome or the quality of life of that person's family. Personally, I'll say, I feel like the luckiest mom on the planet. I really do. In response to the advocacy of organizations like the Down Syndrome Society of Central Ohio, or here in Cleveland, the Upside Down, and many other organizations in a variety of states, states passed, about 19 states now, I think, at my most recent count, which I'll admit was not in preparation for this presentation, have passed information laws requiring doctors to share non-biased, accurate information with expectant parents who receive a diagnosis of Down syndrome. These organizations also worked and continue to work to educate doctors. So for instance, for a while, I was participating in mock diagnosis deliveries by doctors. The organization that I work with goes to grand rounds and gives talks. And although it's anecdotal, because as far as I know, no one has isolated for the variables that you'd have to isolate for to have some sort of significance to the data, the birth rate in Ohio went up. So I really want everyone to put mentally a pin in this, that the information laws appear to have worked toward that point of consensus politically. The birth rates of children with Down syndrome went up, and increases in birth rates correlated with the provision of more accurate and meaningful information about the condition. Later, Ohio, and I think 10 other states passed a ban on abortions sought because the fetus had been diagnosed with Down syndrome. The laws vary in their language. The Ohio law prohibits any person from purposefully performing or inducing or attempting to perform or induce an abortion if they have knowledge that the pregnant woman is seeking the abortion in whole or in part because of a test result indicating Down syndrome. The law did not criminalize the action of the mother, but instead created a fourth-degree felony relating to the actions of the doctor, who also would lose their license to practice. Some states, like Kentucky, ban abortion for reasons of a diagnosis of Down syndrome or any other disability. Louisiana bans abortions sought solely because of a diagnosis of a genetic abnormality. In my home state of Indiana, abortion was prohibited when a provider knew that the reason for the abortion was the child's sex, race, diagnosis of Down syndrome, disability, or related characteristics. So some of the laws are more narrow, others are more broad. Those laws that are more broadly drawn often do not define genetic abnormality or disability, leaving those things open for interpretation, which, not related to my presentation, I find to be particularly dangerous. The Seventh Circuit struck down the Indiana law in a case called Box, but in that case, Judge Easterbrook, in a dissent, noted that there was an intellectual difference between anti-abortion laws and anti-eugenics laws. Justice Thomas, in the denial of cert from the Supreme Court, seemed to embrace this as a distinction. But what does eugenics mean here? In the past, we've conceptualized eugenics as stemming from government or organized group action. Someone raised this question earlier, and thank you, coming back to Ruth's point that I don't know what else new we would say. Can an individual choice, when aggregated with other individual choices, rise to the level of eugenics? Or is the co-option of the term eugenics on the right disingenuous? if individual choices can be aggregated in a way that creates eugenics, then maybe there would be a societal interest in avoiding those individual choices, and maybe that societal interest would outweigh the right to choose. And I think this is the reason for the use of the term. The Down syndrome abortion laws gave anti-choice groups a different moral argument to use as a trial balloon for the eventual overturn of Roe. Choice writ large may have the same effect, I think the argument runs, as programmatic effect, or the same programmatic effect as government regulation if everybody's making the same choice. It's easy to reach people on both sides of the aisle with an argument that we should prevent eugenics. And making Down syndrome a test case for this argument falls into the conservative pattern of using children with Down syndrome like the World Wildlife Fund uses the panda. I have many other examples I could give, but for an example of this behavior in Ohio, you could consider school choice vouchers for kids with disabilities as the test case for the broader availability of school vouchers. Post-Dobbs, does this use of what was a traditional liberal interest to forward an illiberal cause really even matter, or is the battle lost at this point? With that question on the table, I want to turn my attention to IVF. The Alabama fetal personhood law, which applied not only to fetuses, but also embryos, and LePage case. As Professor Jonathan Will and others have noted, personhood laws, like the one at issue in LePage, have implications beyond the mere availability of IVF. If all embryos are defined as persons under a state's law, and if a state's highest court upholds that law, states may regulate implantation or preservation of embryos on the basis of genetic characteristics like disability. The United Kingdom, for example, currently has a law that prohibits prospective parents from discriminating among available frozen embryos on the basis of, this is a quote, genetic abnormalities leading to serious physical or mental disability, serious illness, or other serious mental condition. However, those terms, abnormality, serious physical or mental disability, serious illness, or serious mental condition are poorly defined. Again, this is really dangerous. As Professor Dorfman's recently documented, the UK law was the result of moral panic over deaf parents' choice, not even to use IVF, but of deaf parents' choice to use a deaf sperm donor out of the desire to have a deaf child. Here in the United States, with Dobbs on the books, the next target of control over reproductive rights is likely IVF. We're, I think, watching it happen now. Banning access to IVF will deny the right to choose of a family whose age, health, or disability prevent unassisted pregnancy. So already, this impinges on the rights of the disability community. But very few states will, I think, have the guts to ban IVF outright as an initial matter. Instead, I believe legislation here is likely to follow the path that was laid out for abortion, and a step along that path is prohibiting discrimination in the implantation of embryos on the basis of disability. And that language, I think, would be narrow. My guess is the language that will become prevalent is language that prohibits discriminating among embryos on a genetic basis. The rights co-option of the language of eugenics provides the necessary moral panic to support legislation in this manner, and the co-option of faces like my son's provide the panda effect that's necessary to create a coalition around goals here. And note that the law described, a law described in terms of discrimination would prevent not only choices against disability, like the Down syndrome abortion bans have done, but would also hamper choices of disability, choices for disability. Now, where's the eugenics argument? Down syndrome or disability abortion bans ostensibly aimed at protecting embryos and having more babies, and IVF regs aimed at protecting embryos, but likely to result in fewer babies, seem to be in some ways purposively in tension with one another if the focus is babies and preventing group level eugenics if such a thing exists. This is especially true if IVF regulation prohibits the selection of embryos on the basis of genetic characteristics rather than focusing narrowly on disability. And under such a rule, a deaf parent could not select for embryos carrying genetic markers for deafness, for example. And so this anti-choice focus on eugenics just completely falls apart. I think this really puts the lie to the use of that term on the right. If instead we recognize the purpose of both sets of laws, the Down syndrome and disability abortion bans and IVF restrictions as control, it explains why legislatures in red states have been compelled to look away from the thing that really worked, which were information laws. Information laws are autonomy increasing for parents because they allow parents to make a real decision with fuller information. These laws also restore dignity to, in my case, folks with Down syndrome by more fully describing them instead of horrifying prospective parents with highly salient medical risks. Abortion bans and their focus on control rather than autonomy roll things back for my son. I honestly believe that some of the people in Ohio who supported them believed that they were doing a good thing for the Down syndrome community. But if I were pregnant with my son today, I would not have the privilege of choosing him. He would not have the privilege of knowing that he was wanted instead of forced on me. The Down syndrome abortion ban robbed my son of a piece of his dignity, even though it did not come into effect until after he was born. And in passing it, the state signaled to people with Down syndrome that others systematically place a low or negative value on their lives. Before I wrap up, and I hope I'm not over time, but I suspect I am, I want to return to the language of privilege. I had the privilege of choosing my son. I had the education and power and financial resources and job flexibility to do that. And because of that, my son lives with the privilege of knowing that he was chosen. In her 2022 article in the California Law Review, Professor Chiara Bridges describes something much different, which she calls the dysgenic state. She argues that disability abortion bans, like the one that was in place here in Ohio and like the one in place in my home state of Indiana, will concentrate disability in low-income communities affected by industrial toxins and other conditions that favor genetic differences, as Dara mentioned earlier. In those communities, disability abortion bans add to an existing burden on autonomy in choices around disability and around reproduction. Environmental conditions and lack of appropriate prenatal care make disability more prevalent, but which is not necessarily a bad thing in my opinion, but the lack of financial support and inadequate social service delivery make it more difficult for families to care for and educate themselves when their child has a disability. With the net effect of exacerbating inequality between affluent communities that have folks with disability and low-income communities. And these communities are often, as we know, separated along lines of race, especially here in the Midwest. One way of, I'm sorry that I'm harping on this. One way of addressing this disparity, not fully, but at least in part, is to back off the abortion bans, not likely to happen, and to push information laws, which we can still have. We can still have information laws, even if there are disability abortion bans in place. And to push for the provision of adequate social support for disability. And those are a couple of things that we can actually do. So what can each one of you do from here? You can look at your own state's laws. I'm assuming that a lot of us are from Ohio, but not all of us are. And you can look at your state's laws. If your state has inadequate laws around prenatal disability diagnoses and early childhood intervention, you can organize around this low-hanging political consensus fruit. This is something that really works and actually helps. And finally, and importantly, let me close with this. We can't lose sight of the anti-choice movement's use of pandas and scapegoats to divide opposition and to put forward an agenda. I cannot tell you how sick to my stomach and tired I am of people using faces like those of my son to push an illiberal agenda. The use of Down syndrome in support of abortion bans is not ideologically different from the use of trans kids to attack Section 504. These are the same thing. Behavioral psychology has become a front in this fight, and a way that we can push back against that is education. All right, that's it. Thank you.
Thank you so much, Professor. I'm so glad we're talking about access to information because that is such an important piece of self-determination in our choices and preserving bodily autonomy. And I'll share really quickly that, I read a survey before I went to the National Abortion Federation's annual meeting last year to present on the topic of improving access to abortion for people with disabilities. I read a survey about parents who were parents of kids with disabilities who had reported that they more often than not received the information about their child having a diagnosis in the womb, that their fetus had a diagnosis in the womb, that they had received that information really negatively from providers, and providers had delivered that information as like a devastating piece of news, and that had been a really hard thing for them, and it had put pressure on them to access abortion when that wasn't necessarily a choice that they were initially interested in. And when I went to NAF, quickly after that, I was in a session about counseling for people who were considering abortion. And there was a counselor there who was leading the session. She was like very seasoned, had been doing this for 30 years. And we got to the part where we were talking about prenatal diagnosis. And she said, the first thing I said is, I'm so sorry. I'm so sorry. And she just delivered that like with her chest. And I was like a little baby lawyer in the back of the room, like, actually, like what's better is we should be providing scientific, neutral information to folks about the impacts of conditions on their lives, like positive and negative, like scientifically neutral information, access to support groups. And it was just the counselor, I was speaking into the microphone and she was just like, oh, yeah, wow. Like it was just so shocking and like mind blowing to her. So that just kind of speaks to the importance of like doing this work. There's still so much work to be done in the reproductive justice and rights spaces. So thanks so much for bringing up, information. It's really important. And now we'll move on to Dr. Hattie Freeman.
Thank you. Great, thank you. Good afternoon. I'm so excited to be here with you all and hearing so many interesting.
Move the mic to your phone.
Hearing so many interesting talks. So I am a white woman with wavy reddish hair, and I'm in all black, down to my black Birkenstocks, except for my purple glasses, because purple is my favorite color as well. So I'm not a lawyer or a law professor. I'm a reproductive and forensic psychiatrist. Reproductive psychiatrists are medical doctors who treat women at all ages, but particularly from menarche, then dealing with issues related to like PMDD, for example, to pregnancy, abortion, postpartum, and then also the menopause transition. So I'm a reproductive psychiatrist. Miriam Rosenthal, who worked in the space for decades, was my mentor in reproductive psychiatry. And I'm also a forensic psychiatrist, which means I'm a psychiatrist who interfaces with the law in different ways. For me, it's predominantly criminal law. And then I teach the psychiatry and the law course here at Case Western. So I want to talk today about some of the intersections of psychiatry and pregnancy termination. And you can imagine I could go for a very long time on this. So we're going to talk about a couple of specific topics. If you could give me the next slide, please. I think it's important to be aware of where we came from with psychiatry and the law. And some of this I learned from my mentors and then from reading as well. And this is an article that you can freely access that we wrote that's in the Journal of the American Academy of Psychiatry and the Law, kind of exploring the history of where psychiatry was with abortion and some thoughts about the future. Next slide, please. I'm going to talk today about two points. First, psychiatry and our involvement with pregnancy termination, and perhaps some misuses of psychiatry in this space. And then talk about also some of the research and some of the misinformation out there, because I think we're talking about the importance of real information versus some of the misinformation that comes out. And in that part, I'll briefly talk about informed consent, as we've been hearing about as well. We can skip through the next slide. And we're all aware of what we're here for. Historically, before Roe v. Wade, illegal abortion was common, and abortion was the cause of death for about 18% of deaths in pregnancy and childbirth in the 1930s. Then by the 1960s, the British Medical Journal talked about psychiatric grounds to obtain abortions. In cases of fetal anomalies when the mother was experiencing anxiety about the anomaly. So there's a lot of interesting use of words in some of this, as opposed to like the actual psychiatric definitions of disorders. Moving to the next slide, please. So we all here know that many states had significantly limited abortion prior to Roe v. Wade, but there would be psychiatric exceptions, and occasionally these appear to be true psychiatric exceptions, but really it seemed to be a way to kind of force the issue of abortion into psychiatry with some kind of negative ramifications, especially for people who did not have means or were not in urban areas where they maybe had choice of psychiatrists that they were seeing. Next slide. So psychiatrists then, prior to Roe v. Wade in this country, became gatekeepers for abortion. So what they would have to argue for a psychiatric rationale for an abortion was that a woman was going to be imminently suicidal if she wasn't allowed to have an abortion. Now, in the rest of the psychiatric world, if someone's imminently suicidal, we try to get them admitted to the hospital for treatment. However, this is a special case where we can certify someone suicidal, but then we have a medical procedure instead for that. It was not research-based at all. So you can imagine what happened then, similar to what's happened now in another sort of evaluation I'll talk about with relation to informed consent, is that certain psychiatrists with certain ideologies always went one way about their opinion, and other psychiatrists always went a different way with their opinion. Next slide, please. So by 1969, both the American Psychiatric Association and the Group for the Advancement of Psychiatry were saying this doesn't belong in criminal law. Next slide. And this is because it was psychiatrists who were becoming involved in these cases preeminently. So, Case Western Reserve Law Review, look at that, and it's a psychiatrist from the Cleveland Clinic down the street writing in it in 1972, so pre-Roe v. Wade. And he wrote that although the practice of abortion has been illegal in most states until recently, 1972, it has been a quote-unquote open secret that a woman can obtain a safe abortion in a licensed hospital if she can find a psychiatrist who will say she might commit suicide if her pregnancy is not terminated. Next slide. And then, similar to the lack of data 50 years hence, he wrote, it's impossible that on any scientific grounds to establish agreed upon indications for a quote unquote psychiatric abortion. And then there's this discussion in the older literature too about, are we forcing women to act a certain way to get the psychiatrists to then say these things? So he writes, it favors the histrionic, the emotionally unstable, the deceitful woman, allowing her to abort. But not the woman who's truthful and acts in an apparently stable manner. But of course, there's this third point here as well. I quite like this quote, depending far less on the state of her health than the state of her pocketbook. So she can afford to go find whatever psychiatrist she will. So then next slide, please. What's described then throughout the literature then is this paradox, right? She's so at risk, she's gonna kill herself. She needs this abortion, but we're not going to psychiatrically hospitalize her. Next slide. Thank you. So then what happened is psychiatrists, as I was implying, went with their political opinions often rather than actually the situation in front of them, which there was no scientific basis for anyway. So some people would say, I'm not going to participate in this at all. It's a complete misuse of psychiatry. Some people would say, for religious reasons, I can't become involved in this. Then others would authorize some abortions. Some other people, I've heard Tail would authorize every abortion. But that also would have been an unpleasant place to be because you're doing it with this misuse of the profession that you're part of. And so some would certify all cases. So then I also think about, like, what about you live rurally and you actually do get to see that psychiatrist, but there's one psychiatrist, and if they're anti-abortion, then nobody's gonna get one. Next slide. Okay, so that is where we came from. And yes, both of my mentors were involved in the 70s or 60s, I guess, in those evaluations. Then through the Roe v. Wade era and until today, capacity evaluations are often asked of psychiatrists in abortions. And so this is something that's been talked about a little before. I want to talk a little bit about what informed consent is from a psychiatric perspective, just to review a little bit about what Professor Harris was saying. But also, just to point out as I'm saying it, it's not a super high bar, and yet there's often a presumption that maybe someone with bipolar disorder, someone with schizophrenia is not going to be able to have informed consent. And so you think about with short periods of time that people can access abortion, and someone may want to see a referral to a psychiatrist that says the person has the capacity to provide informed consent. And so then getting that appointment and having that all for a very usually not taxing assessment of informed consent. And if that even adds 2 weeks or 3 weeks to the person's opportunity, then that's concerning. So informed consent is something that psychiatrists assess all the time in the medical hospital. So someone has delirium and they need a surgery, and we want to find out, do they have capacity to provide informed consent? It's specific, as was talked about, for capacity for the specific thing. So this is for a medical procedure. And then like I said, we do it all the time for other medical procedures. And somehow it's not complicated in those situations. But then when you make it about abortion, a lot of people have difficulty completing the evaluation because of personal concerns. What we usually need to see for informed consent is that someone understands their diagnosis or their medical issue. They understand the risks and the benefits of a procedure. And then the pieces that we were hearing about earlier, they can communicate a choice, they understand and manipulate the information, and they appreciate the consequences of the situation. Abortion, as we know, is a medical procedure. It does have some risks, but many medical procedures have risks, and many surgeries have much greater risks. And I don't think that's quite as often people's capacity for the informed consent comes into the picture. Complicate that with the widespread misinformation that we hear in some of the informed consent laws on the next slide. And then how that evaluation is completed. So I absolutely agree about us wanting autonomy with more information. The problem is some of the misinformation. So on the next slide, my colleague, so my colleague Jackie Landis pulled this together. Abortion risks and some of the informed consent information in Texas talks about a risk being depression or thoughts of suicide. We'll talk more about that in a minute. Malaise, irritability, depression, PTSD, sleep disturbance, loss of interest, breast cancer risk, etc. And these being misinformation due to bad, poorly designed medical research that the public has difficulty knowing is poorly designed, which we'll talk about in a minute as well. The next slide, I just wanted to briefly also talk about Jane Doe evaluations, which are a type of informed consent evaluation that we have been called on to do in the past as well. So Jane Doe evaluations, just very quickly, are minors in a bunch of states. If a minor wants to have an abortion, but to bypass the parental notification and consent process, she may be evaluated by a forensic or a reproductive psychiatrist or psychologist to determine if she has the capacity to provide informed consent for the procedure. Now in our studies, they tend to be older teenagers. They're 16, 17, and they're knowledgeable, and they perhaps have means to know about this and be able to present for this. And then it's also the weirdest type of forensic evaluation I've done, because, for example, I do insanity evaluations, I do incompetency to stand trial evaluations, and usually we gather all sorts of collateral information. We have the luxury of time to think about a case, but in these, there's not collateral information. We don't even know her name because she's Jane Doe, and we usually, there wouldn't be a report when I was involved in these. We would one would just go to court and testify, and then depending on the judge you might get, it might be an unpleasant experience for the young woman and for the doctor testifying, because of kind of paternalistic views put upon things and questions asked. But when you get to the heart of it, this is an informed consent evaluation too. It's just on a 16-year-old, 17-year-old instead of an 18-year-old. But we would still see people not wanting to do them because of their religion, et cetera, when it's a capacity for a medical procedure evaluation. Okay, next slide. I would like to turn briefly in my short remaining time to talk about the abortion research from a psychiatric point of view. The APA even put out a report because of these problematically designed studies. And I think even when I'm training our junior doctors about them, it's hard for them to see what the flaws in the methodology are. I did do a research fellowship, so we can knock it out pretty quickly, but otherwise it can be difficult for people to tell. So there's maybe 4 big issues in them. It's failure to address confounding issues. It's looking at the wrong comparison group. So instead of looking at women who wanted an abortion but couldn't have one as the right comparison group, it'll look at happy suburban women who wanted their pregnancy as a control group, and that's not how you do research. So inadequate control groups, and then not thinking about the characteristics of people, right? So if we know that 3/4 of women who have abortion are of lower income, then is the same true of the control group. So then the Turnaway study on the next page, which has had lots of different articles published about it, really thought about those things and controlled for them. So they used the right control group of women who wanted an abortion but couldn't get one. When they looked at the psychiatric effects as opposed to the other studies who were comparing apples and oranges, your mental health before the abortion is the most predictive of mental health after the abortion. As is logical also. Okay, next slide. There's just a couple things we're trying to do from advocacy through education standpoint. So this is an article that we wrote for psychiatrists in the wake of Dobbs to think about psychiatrists or doctors. We can prescribe and prescribing emergency contraception in advance to patients. And so we've been doing some teaching around that locally as well. And then the other thing is there's a national curriculum for reproductive psychiatry, and they were convinced after Dobbs that we needed to be educating psychiatry trainees nationally about pregnancy termination. And Jessie Hill joined our small group to write about that and educate psychiatrists around the country. So I will wrap up my remarks there. Thank you very much.
Awesome, thank you all. Now we'll move to the questions portion, and I would actually like to start with a question, if that's okay. So we've been talking, several of us have brought up the concept of informed consent and capacity to consent, but we haven't touched in depth on the ways to support people with disabilities and support capacity to consent. And so I'd like to talk a little bit about the importance of supported decision-making and how that can intersect with reproductive justice. And then I'd also like to talk a little bit about the concept of the dignity of risk as it relates to decision-making and supported decision-making for people with disabilities.
I'm happy to get us started if that's okay. It's hard to tell here. Okay. So the concept of the dignity of risk being what many people in the room probably know, Robert Persky from the sort of provider perspective as an advocate in the 1970s said the dignity of risk is the ability for us to make good and bad choices. You know, obviously both those terms are normative and heavily weighed, but the idea that people with disabilities are often denied the dignity of risk because they are not allowed to make what are considered poor choices because it's circular, and then therefore those poor choices are deemed to be evidence of their incapacity to make their own decisions. And so it's that circular argument there. In terms of supported decision-making, Jillian, I agree with you 100%. I think there is a role for supported decision-making in this story. And in fact, it's already there. The main question is whether the law recognizes supported decision-making in terms of informed consent and the kind of barriers that we've been talking about all afternoon to having providers see supported decision-making, as a valid way for decision-making to take place, given that informed consent is an individualistic concept. So the push is, look, we all make decisions based on information and advice that other people give us. I do this exercise with my students where I say, think about a really hefty decision that you all made in your life, which is to go to law school. How'd you make that decision? And I have them all kind of deconstruct it and talk about that decision-making process. And I say, okay, so is that an individual decision, or did you actually make a decision using supported decision-making? And the answer is yes. The biggest challenge, I think, is going to be, how do you see this intersecting with a legal system that is heavily individualistic and not set up in terms of legal concepts for this to work? I think the move for supported decision-making has tremendous potential, but we do have to wrestle with some of those fundamental first-order questions.
I think that one little thing that actually draws on your talk, actually, wrote a law review article that just surveyed each of the state's so-called informed consent statutes on abortion. And, I remember I published it, but, someplace, but it was. No, I think it was you, but it was mind blowing to see how distorted the language of these pamphlets that every state required pregnant people to receive before they could make a choice when abortion was legal, to choose to terminate the pregnancy. And so talk about supportive decision making, it was like the opposite of supportive decision making because the decision began with misinformation. And so, I mean, we're at a time now, right, where facts don't exist, and we all know this, but this is old news. This isn't Trump. We can't blame Trump for this. This existed long before he even ran for president. And so I wish we could repeal those statutes. I don't think that's probably likely to happen. But it's, yeah, I mean, they say all sorts of, your breast cancer risk increases, you're gonna be suicidal. I mean, what, and then the other thing, one of my pet peeves is no one ever counsels women and other people can become pregnant, but what it's like to be pregnant and to be a parent. And like, why don't we have the consent for that too? It's like it's so one-sided, right? And in the term context, the teenagers, okay, so if we don't let them have an abortion, they're mature enough to go to term. I mean, that's a bizarre way to think about it, right? And so, I mean, I guess it doesn't answer your question, but I don't want to throw that out there that it's the whole informed consent framework in the abortion context is completely bogus. Like it's not about anything that looks like informed consent elsewhere in the legal system.
Or the medical system, right? Like there's no other medical procedure I can think of where there's like a law that you need to give this false information before you can have your knee operated on. I think the other thing I wanted to say in response to your question too is, I mean, in my field of reproductive psychiatry, we try to move toward preventive ethics, right? So people with mental health disorders have higher rates of, like, everyone has high rates of unplanned pregnancies, but people with mental health disorders have even higher rates. And so thinking, especially in the wake of jobs, like, can we help educate people, get them not only emergency contraception, but other contraception? Because also there's so much misinformation about psychiatric medications in pregnancy. And we need to be, thoughtful about all of that things.
Thank you. This has been so fabulous. Thank you all so much. This is Madeline Marcel again from EdHelp. I have a comment and then I have a question. On the topic of supportive decision-making, just building off of what Professor Harris said, I wanted to note that we advocated for HHS to acknowledge that the importance of reasonable modifications in supporting informed consent in the context of discrimination in medical treatment in the 2024 final rule on Section 504, and they did. And so there's really great analysis in the preamble that bridges the idea of supported decision-making into what does implementation of this non-discrimination law look like? And we asked them to do that broadly, as well as in a sexual and reproductive health context. I can't remember if there was sexual and reproductive health analysis in the preamble to the final rule, but the reasonable modification and supportive decision-making piece did make it in. So I think that's one way, but again, like, these rights are only worth as much as people are aware that they exist, and there's a lot of backsliding happening right now, but I did want to note that. My question is for Professor Hoffer. Thank you so much for your presentation. I learned a lot. I'm so interested in what you talked about as laws to ensure that people are receiving information as an intervention to support reproductive justice, which is, for those who may not be aware, not just the right to choose abortion, but the right to have children, not have children, raise the children we have in safe, healthy, sustainable communities, and the right to bodily autonomy. And I think so often about a lack of information as an impediment to achieving reproductive justice. And I'm so curious whether there have been, you talked a little bit about like the data on increasing birth rates and supporting that exercise of reproductive autonomy for pregnant people. But I'm so curious whether you have seen any or created any legal epidemiological studies really quantifying that, like the impact, the measurable impact of those laws, because I think that would be such a valuable tool.
I do not know. I looked in advance of this talk to see if I could find anything like that. I struck out and my law librarian struck out, but that does not mean that it doesn't exist. That just means we had trouble finding it from the law school. This is something I absolutely would love to do if it doesn't exist, but I think that would be really valuable. I think it's difficult to separate out the passage of these laws from everything else that's happening in the background over the past 10 to 15 years in terms of abortion and changes in social services. So I think it's a heavy lift. I wish I could find it, and if it's not in existence, I'd love to help create it.
Thank you. Yeah, this was really wonderful. Thank you so much. So I actually am going to squeeze two questions in. One is for Professor Hoffer, kind of going along these same lines. I was just interested because Professor Kolker and Dr. Hatters-Friedman were both just talking about how much misinformation gets kind of introduced into the conversation under the guise of informed consent laws. And I was just wondering, like, I think Ohio's law for the Down syndrome consent is, or, information rather, just sort of defers to the physician and said, must give complete, I can't remember exactly how it's drafted, but I guess I was wondering if you could talk a little bit about like how those laws are written that are not, or are there some that are written in some states that are intended to kind of put them on the scale or not, or do they tend to like, require certain particular information? Are they more kind of neutral?
Again, this isn't my area of scholarship. I've read a few, but not all. The ones that I've read are all fairly similar. That doesn't mean they're all similar. In Ohio, the law requires information to come from two sources. One, it has to be provided on a website by the state. And Down syndrome advocacy groups worked with the state to create that language. So the state was accommodating in that way. And the second source is from the doctor. There is an organization called Lettercase, which is a Down syndrome advocacy organization, which has been part of the source for the big push for these laws. And Lettercase creates a package of materials to give to obstetricians. So a lot of the advocacy organizations here in Ohio were raising money to purchase these packages of information and then delivering them. So part of what I did was I had a regular monthly route to like 6 different obstetricians, like, are you out of Lettercase stuff? Here's some more stuff, right? And so though there wasn't a requirement, I don't think that the information be uniform, merely that it be balanced and accurate. I think the information wound up being fairly uniform in Ohio, and probably not just in Ohio, but in other states that have this law, because of the work of the coordination of advocacy organizations in this area.
So that's interesting. Yeah. Thank you. And then if I could squeeze in one more. All right. Okay. For Professor Harris, I think this is such an interesting topic, and for me, I find about approximately once a year, I get a call from a physician who says, I have a patient here who I feel who is pregnant, who's been brought here by a parent or something like this, seeking an abortion. I do not feel that this patient can consent because of their, they don't have decisional capacity, don't understand what's going on, have made that assessment. What do I do? And I've looked into this in Ohio law. There's like not really an answer legally. like, also though, I guess I just wanted to ask you, like, if you have thoughts about kind of how that situation might be different, or what, like, because I feel like there's no default answer, right? Like, if you have, and maybe this is not the right, maybe this analogy doesn't work, but I just feel like, if you have a tumor that is malignant, like, the default would be take it out, right? But here it's not clear what the default choice is, so, like, just, I don't know, is that something you've encountered, thought about? Would love to hear your thoughts.
I think this is a fabulous question and a really hard one. I don't think anyone is really making strides in the way that, certainly from my own research, where I would feel like it's sufficient. But you could imagine, just kind of thinking out loud, that you could have think about it in the context of lawyers. So if we encounter a case that we're not sure and we feel this could raise some serious questions, we hit the pause button. So the question is, how long can the pause button be on for? So it's a question of time, right? If time is of the essence, that's a factor. But could you then seek additional guidance? Could there be a state, I'm going to use the legal context again, is there a state board that provides, in the context of the medical board would be the equivalent, I guess, but to provide guidance on these tough questions? And so there are lawyer assistance lines, there are organizations that are set up to help work through some of these questions. And you can do it in a nonpartisan way, and where you could have people come together and sit on these boards the way that medical boards do it. That might work, that might not work. But I think the considerations are the most important, which is, the time element, the idea that whether it's for the individual who's seeking abortion, they may also want more time to work through this, or they may have, it might not be the right day to have this conversation. And so maybe that doctor would have an additional visit the next day, or, there's so many factors at play. And I think capacity, even within the context of a day, varies and waxes and wanes. And so we have to kind of set up a system where there are doctors and providers, as well as resources for the individuals seeking an abortion, to have that extra time built in, and to have the ability to do that. And if capacity, there might be a question of capacity that's real. And so we have to also be cognizant of that element too, right? Where the voluntariness, the coercion is an issue. And so we have to develop a system, and I don't have it worked out, but a way in which we're looking at the factor of time and allowing for additional processing. Because what we have right now doesn't necessarily get us there, either to the urgency of making the decision or to the importance of getting the decision right.
Can I add something? This is Jillian again. And again, thinking too about reasonable accommodations, whether that person's capacity has been assessed with accommodations in place. So that can include things like using plain language, using a teach back method, having like a plain language outline of the information discussed in the appointment, having multiple appointments, having a supported decision maker there with the person. I believe it's something like 31 states have language in their guardianship laws that say that less restrictive alternatives must be utilized and considered before guardianships can be put in place, because sometimes doctors feel, oh, well, if this decision is going to be made about a reproductive choice for a person with a disability, then there needs to be a guardian involved, which is not necessarily true. And many states actually require less restrictive alternatives. I think it's something like 18 or 16 states mention supported decision-making in particular. So the question should always be to the doctor as well, like, has this person's capacity to consent been assessed with their requested reasonable accommodations in place? And like Professor Harris mentioned, that can be things like changing time of day, because medications may be taken at different times of day. People may be groggy in the morning, allowing for additional times at appointments to interact with the supporter and the person with the disability. And to have those discussions as slowly as they need to be had and in the plainest language, using visual aids. So those are all tactics that doctors can use to support a person's capacity, because their capacity to consent should be considered with accommodations in place. And I think sometimes doctors aren't always thinking about that additional layer of accommodations that can support a person's capacity.
Awesome, thanks everyone. I did want to note really quickly before we wrap this panel up, that Ohio is one of those states that does require least restrictive means in their guardianship evaluations. However, it's still not being used as frequently as folks would like, so there is a real big push going on in the state of Ohio right now to put supported decision-making into our laws to reinforce that. It just got taken out of our budget yesterday, I heard. So, it's something that if you're interested in getting involved in Ohio locally, the Supported Decision-Making Network of Ohio is doing a lot of work on this. And I would be happy to connect you if anybody is interested. Okay, so we are wrapping up this panel. Thank you all for being here and helping.